Hey there everyone, my name is Cameron Gallucci and I'm going to be speaking to you today on behalf of TexasCountryLawyer.com. In this video we're going to further dissect the meaning and the assumptions attached to alimony. Is it your friend or is it your foe? Do you even know what it means? That pretty much, I think, generally depends on what judge is going to be residing over your case, along with how experienced and suave your attorney is. But there are very many other factors involved. So we're going to go over those today, and maybe that can help you better navigate your process and foresee your outcome with it all. Since 2011, Texas alimony laws have drastically changed. Legally known as spousal maintenance. Remember that. When you're in a courtroom or when you're reading through all those legal documents, it's not going to say alimony, it's going to say spousal maintenance. Anyways, legally known as spousal maintenance, alimony's primary purpose is to avoid the unfair economic consequences of divorce, or therein, the potential financial pitfalls that you might experience afterwards. This is calculated after the property is divided and the child support is awarded. So at the end of the month, when you're balancing out those checkbooks, don't get those terms or those bills confused, because one is not the other. Let's look at a hypothetical so that maybe I can better explain this to you. Let's say that after 12 years of marriage, a couple decides that they're going to divorce one another. At the time, the wife was earning $63,000 a year, and at her company of employment, she had the potential to reach a top notch of $80,000. When they married, the wife was in grad school, so the husband worked full-time, earning an average of $22,000 to support both him and his wife until she completed her studies. After their first child was born, they both agreed that the husband would stay home and care for the child and raise their family. Right on, way to go. But at the time of the divorce, the husband had returned to work, earning an average minimum wage. In this case, it's most likely that a judge is going to award child support, and he or she is probably going to equally divide the marital property and the assets. But would it not seem just a bit unfair for the judge to let the wife leave the marriage with sole possession of the couple's most valued asset, her earning potential? Because do remember, it was the husband who indirectly contributed to that earning potential and any potential that she might have in the workforce when he worked full-time to help her through her studies in grad school. Unlike the family's Harley-Davidson that's collecting dust in the middle of that garage, the wife's earnings have yet to reach their fullest potential. Because remember, they can still grow. She can reach up to $80,000 a year. I think it would probably seem a bit unfair for the judge to rule out the husband receiving any share of future growth, since he not only helped the wife through her studies and school, but he also forfeited his earning power and making a name for himself in the workforce by agreeing to invest in the family and the raising of their children. Courts set very few guidelines in alimony, and it's generally up to the judge to balance spousal contributions and sacrifices during their marriage, therein with the needs that arise after the divorce. Remember that it's basically left up to the judge and his or her perception of the case that is brought before them, and his or her legal opinion as to what is just and what is right. There are many factors to be considered when breaking down alimony, and because alimony is a very complex thing that has very many elements to it, but when it comes to the eligibility, the primary things to be considered are listed right here on this whiteboard. The first is the financial resource of the spouse seeking the support, and the financial resources of the spouse who is expected to provide it. That's right here, number one. When it comes to the spouse that is seeking the support, prior education and employment skills are also taken into consideration, therein analyzing whatever additional education or vocational training might be necessary for that spouse to reach his or her occupational or career potential. The duration of the marriage is considered. If you've been married for less than a decade, then you're automatically off the books. You are disqualified. You ain't getting nothing. The current income of both spouses, Because remember, even if the spouse seeking alimony is in need of assistance, if the spouse who is expected to provide that alimony has nothing in his or her pocket that can contribute to that spouse, then the odds of you or he receiving any alimony are going down real fast. Another factor is age. I myself remain puzzled as to why age is even included in this, but it is, so do recognize that and do keep your eye on that. The emotional and physical factors that could prevent steady employment or career growth, and that includes caring for a disabled child, because obviously when you have to care full-time for a disabled child, that's going to put a wedge in your career development, your rise, and therein the money that you bring home. And lastly, the efforts that are exhibited by the individual seeking exhibited by the individual seeking this assistance. If the efforts are zero, if you're pretty much, even if you meet all of these needs right here and you have 100%, if you are exhibiting very little effort into getting your job or getting your education, and you're pretty much sitting around doing nothing, then you're out. That's taken into consideration. There are records on that. So, under the new law, some courts have provided exceptions for those who have been disabled by their spouse. But generally, most of them still order such charges to be decided by a jury rather than a judge in a separate civil suit. In this case, punitive damages would be awarded rather than alimony. Punitive damages. Spousal maintenance can be denied, as I said, if the spouse seeking the support has exercised little due diligence in seeking employment and developing the skills necessary to become independent and self-sufficient. You know, if they're not doing anything, then what's the point in supporting that? You don't want to support lack of effort. But in contrast, individuals cannot be held accountable for the social injustices, and therefore gaps in earning that are generally exhibited by the workforce that tend to favor men over women are not acknowledged by the court system. One has no control over the other. They're not correlated, so a judge is not going to punish a male spouse because the female X is not being treated rightly in the workforce. That's just, there's no coordination now. There are really no mathematical guidelines that dictate the calculation of alimony, and each order is decided by a judge on a case-by-case basis, and it's not awarded across the board. So just because your best friend took home a lump sum ruling, that doesn't mean that you're going to get any in comparison to her, even if he or she had a case that was very similar to yours. Because remember, it is judged on a case-by-case basis by different judges under different courts, and not everybody carries the same opinion. Though many states do use the Uniform Marriage and Divorce Act as a model when considering various factors, including these things are key. But in addition to that, other factors that are involved would be a couple's standard of living prior to the divorce, and the ability of the spouse to support the recipient while supporting his or herself. I really do emphasize that even if you are very deserving of the alimony and you meet all these requirements, if your ex-spouse cannot adequately support you while supporting his or herself, then it's going to go down. Another thing to be kept in mind is that there are restrictions on who can collect alimony, how much can be collected, and, once again, for how long. And I also want to emphasize that just because it says up to 5 years does not mean that you are getting 5 years. You may only get 6 months or 2 years. So that's up to, not 5 years across the board. A judge can order support if the recipient meets the requirements of the Texas Family Code, but once again, it's not guaranteed. And also, if the marriage lasted less than a decade, I say it again, it's off the books. It's disqualified from consideration. Another term that you're going to run into more than once is minimal reasonable needs. Remember that alimony is need-based and that it can only be ordered for a minimum time period. And minimal reasonable needs. Remember that. Depending on the conditions, a max of $5,000 a month or up to 20% of average monthly income will be awarded to the spouse who is seeking the alimony. The amount set is intended only to cover the seeker's minimal reasonable needs. It's not supposed to be a savings fund that you stash your extra coins away in. It's supposed to meet your minimal reasonable needs. So just remember that judges are not required to award it, and it's not excess pay. If the decree doesn't define an alimony end date, then the payment usually remains until the court who ordered it ends it itself. Though 9.5 times out of 10, alimony does end when the recipient remarries. I think it's pretty just law that the court does not acknowledge a spouse who goes and remarries and brings additional income into his or her household is to be classified as dependent on ex-spouse when they've got a new spouse to fill in the shoes. So, but once again, that's not written in the code of law. That is general judgment. Other circumstantial changes, like a drop in the payer's income or a rise in the recipient's income, is also going to reduce or end alimony. Alimony is meant to address the issues relative to the marriage and the needs caused by the divorce, nothing unrelated. So let's say that the wife, after the divorce, the wife's mother becomes ill and therein dependent on her. The wife's needs are going to increase, obviously, financially for multiple reasons. Her needs are going to increase, but it will not increase her eligibility for additional alimony because the two circumstances are unrelated and they occurred during different time periods. The wife's mother did not become ill while she was still married to her husband, and therefore that was not factored in. So it's unfortunate, but it's unrelated to the divorce. Navigating the divorce process is never easy, and therefore I do encourage you to find a local attorney who can guide you through the ins and outs of the process. It will most likely make the road smoother, and it's also probably going to help you to achieve the outcome that you more so desire. So please visit our website at texascountrylawyer.com for further advice on this subject matter and for any additional questions that you might have in relation to your divorce. Thank you for your time today, and adios.